Hi, this is Nilgün Zahour from SM JUROR, and today we're going to be looking at the juror misconduct issues in the case of Chavez versus State, which is out of the Texas Court of Appeals. Some points that I want to highlight that we're going to discuss are that in a motion for new trial, it's the trial court that assesses the credibility of the witnesses. And in this case, we're going to show you an example of how to oppose a motion for new trial based on juror misconduct. In this case, the defendant was convicted of possession with intent to deliver cocaine. He filed a motion for new trial based on juror misconduct, alleging that a juror conducted research on his cell phone to determine the street value of the cocaine. The trial court conducted a hearing on the motion where 5 jurors and 1 alternate juror testified. The alternate testified that just before deliberations, he heard the jury foreman tell other jurors that he talked to someone and learned that the street value of the seized cocaine was $20,000. In contrast, each juror, including the jury foreman, testified that they never heard anyone make such a statement and that no one conducted research on their cell phone regarding the value of the cocaine. Based on the testimony, the trial court denied the motion, finding no outside influence affected the jury's decision, and the defendant appealed. Now, the standard of review with respect to a denial of a motion for new trial is an abuse of discretion. The reviewing court does not substitute their judgment for that of the trial court. Instead, they decide whether the trial court's decision was arbitrary or unreasonable. And a trial court abuses its discretion when it denies a motion for new trial, when no reasonable view of the record could support the ruling. Now, in a motion for new trial, it's the trial court that determines the credibility of the witnesses. If you look at it from the perspective of the reviewing court, the reviewing court will review the evidence in the light most favorable to the trial court's ruling on the motion for new trial, and the reviewing court will presume that all reasonable factual findings that could have been made against the losing party were made against the losing party. What's important here is to understand that it's the trial court alone that determines the credibility of the witnesses. And if there are 2 permissible views of the evidence, the trial court's choice between them cannot be held to be clearly erroneous. Now, Texas has a 2-prong test to determine whether a defendant is entitled to a new trial based on juror misconduct. If we look at Texas Rule of Appellate Procedure 21.3f, it provides that a defendant must be granted a new trial when, after retiring to deliberate, the jury has received other evidence. Now, in order to satisfy this test, 2 elements must be satisfied, or 2 prongs of the test. The first is that the evidence must have been received by the jury, and second, the evidence must have been detrimental or adverse to the defendant. So in this particular case, we want to determine whether the jury heard any evidence about the street value of the cocaine, and then if they did, we want to know if that was detrimental to the defendant's case. So it's under this 2-prong test that the defendant must prove those 2 elements. Now, the holding in this case was that the conviction was affirmed. The appellate court found that the trial court did not abuse its discretion in denying the motion for mistrial, and that there was no error. The trial court chose to believe the testimony of the 5 jurors as opposed to the testimony of the alternate. And since there were 2 permissible views of the evidence, that being that the foreman did hear evidence of the street value of the cocaine, and the opposing view is that no one did any research and no one heard anything from the outside and only rendered the verdict based on evidence that they heard in the courtroom. Those are the 2 permissible views. The trial court's choice was not erroneous. Based on these findings, the trial court found that the defendant did not meet his burden of proof in establishing that the jury received any sort of outside information from the jury foreman about the street value of the cocaine. So again, the conviction was affirmed. Now let's take a look at some specific facts which were pivotal to the outcome of the case. Here, the defendant relied on the testimony of the alternate juror, and the state presented testimony from 5 jurors to contrast that testimony of the alternate juror that no juror volunteered information about the street value of the cocaine. What's important here to understand is that alternate jurors cannot testify about what occurred during jury deliberations, and that's because alternate jurors are excused before the jury retires to deliberate. And finally, the defendant's allegations asserted that the jury foreman learned the street value of the cocaine involved from an outside source. So the state had the jury foreman testify at the hearing that he did not discuss the value of the cocaine with anyone outside of the jury, and that also the jury followed the court's instructions and deliberated solely on the evidence presented at trial. So in this particular case, we see that the state opposed the motion for new trial by going directly to the source of the alleged juror misconduct. Since the motion was based on the alternate juror's testimony saying that he heard the jury foreman talk about the fact that he heard about the outside street value of the cocaine from another person, the state went directly to the jury foreman and had him testify as to the fact that no such thing took place. And then the state also offered testimony from 4 other jurors, which corroborated the testimony of the jury foreperson with respect to the fact that there was no outside information regarding the outside street value of the cocaine, and that the jury followed the court's instructions. So that is it for our case law analysis in this case with respect to the juror misconduct issues. Again, this is Nilgün Zahour from SM Juror. Thanks so much for watching, because the only evidence that you want the jury to consider is in the courtroom. See you next time.